To reopen or motion to reconsider, which one can I file? The answer is it depends. We have to know the standards first. Once we know the standards, then we can guide you properly. In this video, we are going to talk about post-departure motions, whether a person after leaving the United States on deportation order, can that person come back? Bijoux Ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like. Don't forget to comment below. Also follow me on all platforms. Links are in the description box below. Number one, what is the standard? For the motion to reopen, the standard is simple. You have to have some type of change in circumstances. Changes in your circumstances. Or some type of changes in the country conditions. Okay? Then you can reopen the motion. That's the basis, right? Underlining. But when it comes to motion to reconsider, the standard is this. There has to be some type of error, either of fact or of law. In the previous decision, now you're asking the court to reconsider, okay, your case, because that mistake will, in fact, change the outcome of the case, okay? And for the motion to reopen, whatever changes that previously were not there at the time of filing or at the time of trial, if they consider those facts, those new facts, it could change the outcome of the case. Those are the simple standards. Now the question becomes, can I come back? Post-departures, motions. My friend, the answer is it depends. Again, we are talking about immigration law here, right? And it is very challenging when it comes to post-departure motions. First thing to know first, when the person is assessing their case, they have to know what type of bars they have. Is it a 5 years bar? Is it a 10 years bar? Is it a 20 years bar? Let's talk about the 10 years bar, because that's the one I am pretty much working on lately. When the person has been ordered removed by a judge, and they were physically there on the removal date, right? And then ICE executed that order of removal, then the person is presumed to be barred from 10 years from entering the United States. Now, if the person seeks to re-enter the United States, there has to have some type of change of circumstances, right? Or some type of mistake in the fact or law in order to reopen their case, and to allow them to allow us or ICE to facilitate the comeback so that they can present themselves in court. That's a possibility. But nowadays we know that with web hearing, the person can still be outside and be pretty much in removal in terms of hearing from web. But we can argue so forth as far as internet is concerned and all that. That's another subject. But what we really want to talk about today is the fact that there are some type of challenges, right, that it's going to be there. Let's say, for example, the person tried to reopen the case so that they can apply for an immigrant visa outside of the country. What's going to happen is they have to seek permission because the bar hasn't passed. Let's say 10 years hasn't passed. They have to seek some type of permission. That's why the person filed the form I-212, right? And if there is some type of ground of inadmissibility, then in conjunction with that I-212, they have to file again a form I-601 to waive those inadmissibility issues. Is it possible to do it? Yes, it is possible, but it is very challenging, okay? Because of the fact that the person is, first of all, outside of the United States, and second of all, the person has to overcome the bar. And third of all, we have to find out whether the circuit in which the person was ordered removed, if they have not banned the past departure bar, because the emotions, sorry. Sorry about that. But anyway, so that we have to find out what circuit, because for example, in the 8th circuit, they have this law that hasn't been challenged yet in terms of whether or not the court still has jurisdiction over that case, you know. But some circuit, like here in the 4th Circuit in Baltimore, yes, based on Gonzalez's case, we can challenge that. We can pretty much ask the court to still have jurisdiction of a person that has departed, okay, post the departure motions. So we can try here, and it's still going to be challenging. So that's what I wanted to talk about today, right? The standard of the motions, the way to come back, what will be involved, the challenges that we face as far as jurisdiction is concerned, case by case basis. If you need the consultation, because this one is really difficult, challenging, you need counsel, and you're gonna need it. If you need a consultation, please, consultation links are in the description box below. Consultation fees apply as usual. Until next time, bye-bye.